So if you are in the middle of serving as personal representative for an estate, or if you've been nominated to serve as a personal representative of an estate, or somebody has passed away and you've been notified that you could be the personal representative of that person's estate, you might be wondering, can I be compensated for that job? Because it sounds like there's a lot of work and it's going to take some time. The answer is yes, but there are some definite landmines and things you need to be aware of if you're going to be a personal representative and charge for your services. So I'm Dan McKenzie. I'm the owner of the McKenzie Law Firm. We are a law firm specializing in estate planning, estate administration, and small business counsel in the Denver, Colorado area. And just wanted to kind of share some information with you if you're in this position and considering whether to charge for services as a personal representative. So there is a statute on this in Colorado, and I can just show you my screen here. This is a screen of Google, and you can see I've gone in there and typed in the statute number or citation for this statute in Colorado, and you can see when I did that, the first result that came up is a summary, or actually a printout of the statute on the Colorado Bar Association's website. Now, a little bit of a disclaimer there. I don't know how often they update this or make sure that it is the most recent version, so you always got to be a little bit careful, of course, about doing any research on the internet. But you know, it's not like this changes every single year or anything like that. But it'll give you a good idea of things to look at. But you'll see it takes you to this PDF document that does show you the whole statute. It's broken out into several sections, determining how compensation gets paid for people who provide services to a estate. So go there, 1510-601, and you'll see this result. So there's a couple things to highlight here. In the second section, so 1510-602 here, you will see that this is where the right to get compensation is authorized. So a fiduciary, which includes a personal representative of the estate and a lawyer, are responsible or are entitled to reasonable compensation for services rendered on behalf of the estate. And then also, anybody else who contribute, potentially, like I said, provide services on behalf of the estate is also entitled potentially. So different people actually can be compensated by the estate. And then also note down here in section 5 of this particular part of the statute, it says, except as limited or otherwise restricted by a court order, compensation and costs may be recovered pursuant to this section, may be paid directly or reimbursed without a court order. So in some states, you actually have to get a court order before you're allowed to compensate yourself. In Colorado, that's not necessarily the case, but if you take compensation for doing this job, you are obligated for it to be reasonable compensation. And so that is very important here. And so I'll get to that in a minute. But also be aware that if you have, if somebody has asked for you to be removed, you may not further reimburse yourself or your lawyer until that gets resolved. Let's go down to the next section here of this statute. So 1510-603 contains the factors that a court considers when determining whether or not particular compensation is reasonable. So the statute doesn't really say specifically, here's how much a person might charge. Here's the method that they should use to do it. A lot of people really just charge based on the amount of time. But if you read the statute, it doesn't really say that that's the only way to do it or even a way to do it. So I suppose you could do some sort of flat fee. It's important to understand you need to disclose how you're compensating yourself at some point. So this will be reviewed potentially by the beneficiaries of the estate and maybe even the court. So you are incentivized from the beginning to come up with some sort of reasonable way to compensate yourself for this work. And so if you go through section, like I say, section 3 here says the court shall consider all the factors described in this subsection, determine the reasonableness of any compensation or cost. And so again, the court's looking at all these, and some of them might cut in different directions. You know, one might say, well, really that was pretty easy, but the person who was doing it had to miss a lot of work to do it. So you know, there's a number of factors here, and they might not all consistently point in one direction, but you can see time and labor required, of course. We always tell our personal representatives when we start a probate case, you know, from the beginning, keep a log of your time and the tasks that you're doing. And it's a big pain. You know, obviously lawyers charge by the hour, and tracking your time is always a very difficult thing to do, actually, especially even when you do it all the time, but especially if you're not really used to doing that. But even if you think you're not going to take compensation, we usually recommend that right out of the gate, people do just keep track of their time, because sometimes it turns out to be a much more intense process and a lot more time consuming than people anticipated at the beginning. And if you're, you know, 8 months into the process and starting to find out like, oh, this has actually required me to take time off from work, or to travel around a lot, or to just spend a lot of time talking to other service providers about getting certain things done, I really do need to be compensated for this. You know, it's really hard at that point to go back and reconstruct what you did for the previous 8 months. So even if you think you're not going to do it, no harm done in keeping track. And you might find out that it took more time than you actually expected. And then you can see if it will preclude that person from being employed. Like I say, if they have to take a lot of time off from work or something like that, that might be a factor for the court to consider. The nature and size of the estate. Okay, so it's, you know, if it's a simple estate with, you know, a house and maybe a bank account in it, that is a lot different than, you know, tracking down mineral rights and you know, stuff out of state, and dealing with complicated beneficiary situation or whatever else. So obviously some states are a little bit more complex than others to figure out, and that is something the court will consider. Sometimes there's litigation involved. That is a whole other animal, as far as, you know, most probates don't really involve contested litigation. If they do, there can be, of course, discovery, lots of documents, lots of keeping track of records, depositions, all kinds of things that might cause this to become a lot more difficult than it would have been expected at the beginning. Let's see here, this next one, life expectancy, that really deals, I think, with, you can see ward protected person, like if you're a conservator or a guardian of somebody who you're taking care of somebody who's alive. Those are also probate issues, and the longer you're doing that, that would kind of weigh in towards how much compensation you receive for that. Again, time, you know, how quickly did you have to work, and how under what kind of duress, and then, you know, again, detailed billing statements. So adequacy of those billing statements. So like I said, keeping a log from the get-go. If, you know, at the end of the thing, at the end of the whole process, someone challenges it, and you've got a log that's got just very general, vague records of what you did, that's not going to be very helpful for the court. So again, keeping some level of detailed records about what you're doing from the beginning will be helpful if this turns into something that you really need to be compensated for later on. And then, you know, community standards, what are other people charging? Was there, you know, if you are a personal representative and you are an attorney or an accountant or somebody who has special skills related to doing the type of work that you are required to do when you are a personal representative, you might be able to charge more because you actually are, you know, bringing those skills to bear on this whole thing. The terms of a governing instrument, that just means if you are, you know, if there's a will in place and the will says anything about whether that person might be eligible for compensation, that of course will be a factor that the court will consider. And then various courses of action available to a fiduciary for a particular service. So as you can imagine, like there are things that need to be done in an estate process and an administration process that do require some level of expertise or skill that you could hire out. So maybe an example is, you know, a house needs to be sold, and the personal representative goes in and paints that house, like to spruce it up for sale. and then they charge some very large amount for what they did, and someone says, well, hey, you could have hired a painter and it would have been half as much as what you're charging for this. I mean, that's going to be a factor to consider. So, the personal representative doesn't necessarily need to personally do everything. In a lot of circumstances, maybe they shouldn't do that because other people are just already set up. They don't need to go out and buy all the paintbrushes and supplies and everything else that you need to do when you're painting the house, in my example. So, I think we're all aware, especially if you own a home, that there are certain things you can do very efficiently and certain things that make sense to hire out, and that is the same case with estates. And then this last one, so cost effectiveness, again, circumstances existing at the time the service was performed, and so same thing here as far as just making sure that whatever costs were incurred, that it was the right way to go. And so again, yeah, these kind of are same thing there as far as just making sure that any costs you've incurred, there's services provided and there's costs incurred, and same thing on costs. If you go out and buy, we're gonna use the most expensive paint we can find. Again, in my example, so and it's a very modest house in a very kind of an area of town that just the housing prices are not really that expensive and not really the kind of paint that would be used in this type of house. Like that could be challenged too. So, and then keeping receipts on that kind of stuff is very important too. So record keeping, being reasonable. At the end, like I said, this disbursement could be made without a court order, but eventually, the beneficiaries and interested parties have a chance to look in and see, okay, how much did they actually charge? What was the basis for that charge? And if they're not happy with it, they can go back and ask the court to review that using these factors to determine that. So it's just very important, even again, if you're not expecting to do it or you're not expecting any issues, that record keeping still be done very well with the expectation that you might want to do it later on. So hopefully this is helpful. This is again always kind of an area of potential landmines and a lot of things that you have to think about. So if you're in this position and would like to consult with us about that, we're happy to do it. Again, we're the McKenzie Law Firm. Our phone number is 303-578-2745, and we are in the Denver area in Colorado. So thanks for watching, and I hope this was helpful.